Now for what's tipping the scales of justice at a motions hearing for teen murder defendant Carly Gregg on Wednesday, prosecutors cited several discovery violations by the defense. Gregg is charged with first-degree murder of her mother and attempted murder of her stepfather. Prosecutors revealed that they haven't received any witness lists from the defense and have only gotten minimal information. They asked the judge to bar the defense team from introducing witnesses and evidence disclosed after the August 20th deadline.
Most of the witnesses that we have are witnesses that we have gotten from the state.
Okay, the Supreme Court's also dealt with that. There is no exception under the defendant's requirement to disclose witnesses.
Now, the judge ruled that at least one defense witness would not be allowed at trial because of the discovery violations and limited what others could testify to. So will these discovery violations tip the scales against Carly Gregg? Let's talk about it. Criminal defense attorney, former prosecutor Franz Borchardt, still with us. Oh, Franz, it seemed like the judge was a little frustrated with the defense team, saying you guys are seasoned lawyers. What is going on? You've been doing this for 20 years and you can't make a deadline? What are you thinking?
So the optics are they're torpedoing the case to give her what we call an ineffective assistance of counsel claim, Julie. So the viewers understand she's entitled to have effective representation. Effective, it doesn't mean Rolls Royce, but competent, effective, like doing their job. And when they don't do their quote unquote job and it adversely affects her, it gives her appellate issues later on. This is a case that already has some pretty significant issues that are going to be looked at on appeal as to her being tried as an adult, et cetera. So I'm not saying they intentionally torpedoed the defense. What I'm saying is, how hard is it to submit a list? If your witnesses are all the state's witnesses, how hard is it to just Xerox copy a copy of the state's witnesses and say, you know what, Judge, here's our list. It's timely. Keep it moving. So it just looks bad.
Yeah, it sure does, Franz. And I appreciate you saying that, because you have to wonder, these are lawyers that know better, so why aren't they doing better? You're right. Is it to be ineffective, perhaps, to give her some post-conviction relief if she's convicted? Franz, one of the big issues that came up yesterday had to do with a urine test. So apparently Carly Gregg smokes marijuana, according to the prosecution, and she failed her urine test when she got into the detention center right after she was arrested. Let's listen to what both sides are saying, because of course the defense wants to keep the test out.
The state is not attempting to use this screen for quantification, rather for presumption. As pointed out in our response, the defendant has admitted during particular evaluations and through other witnesses that she did in fact use marijuana. She has said that she used it during her assessment with Region 8 as well. She says that she smoked it. This happened on the 19th. She says that she smoked it on the 18th at least.
What the state's wanting to do is take that test and then turn it into evidentiary purposes. They say, well, we just want to have it as like an identification kind of thing. Well, no, they're wanting to, in the reports, they're going in and trying to say whether or not she's under the influence at the time based upon that test, which is an invalid test.
So the judge decided the test is going to only be admitted as part of the prosecution's rebuttal case if we see Carly Gregg pursue an insanity defense. Franz, what do you think? Is that the right ruling?
I think it is for now the right ruling. So the biggest issue is the evidence offered relevant? And if it is relevant, which I think there is some relevancy here, is it more prejudicial than probative? That's the balancing test. And I think there's some prejudice in here. However, a lot of things happen during the course of a trial. A lot of things happen and a lot of things don't happen. And if there's certain evidence that doesn't come out during the course of the trial and all of a sudden it's not really relevant whether or not she presumptively tested positive, and that's what we're talking about, a presumptive urine test. Well, if that's the case, then it may not come in at all. So I think it's the right decision for now, but that decision may modify and change after the close of the defense.
Franz, thank you so much for that great analysis from you, as always. Thank you kindly. We'll let you get on with your day. And stay with us in our next hour for more discussions as court has begun in Florida. We're going to be taking you live there for the Buried in the Backyard murder trial when Court TV Live begins in just a moment. Right now, thank you for watching Opening Statements. So we're heading to the top of the hour. Remember, you can always watch or share the episodes if you like them. We're going to be right back on the other side, live next.